We've worked hard on this issue of patents. They do drive our economy. We know that. It allows innovators to do what they do best while knowing they can get the benefits of their hard work. Good quality patents give small businesses and inventors certainty they can defend their inventions from others who didn't put in the work. And without the rights guaranteed by patents, the engine of our economy, American innovation, simply would not be as strong. And given the power that a patent conveys, a patent issued by the U.S. Patent and Trademark Office needs to actually represent innovation. There are serious consequences for our entire economy when the system permits enforcement of a patent that never should have been issued. Vermonters and small businesses all across the country have suffered these consequences. Several years ago, an out-of-state company asserted poor quality patents against dozens of Vermont small businesses and nonprofits, demanding payments for each every time a business scanned a document and then emailed it. It was a scam. It's an egregious abuse of our patent system. That's why I'm proud of the work we did in 2011 to pass the Leahy-Smith America Invents Act. It's a bipartisan piece of legislation, bicameral, the first real update of our patent laws in 50 years, but it allowed the public to take their concerns about a questionable patent back to the Patent Office for a more in-depth review. And through proceedings created by the Leahy-Smith Act, the scan to email patents were brought back to the Patent Office. They were invalidated. They allowed Vermont companies and nonprofits to continue their work. The Patent Trial and Appeal Board, the PTAB, created under the Act, resolved those disputes in a way that's faster, more importantly, less expensive, more accurate than a district judge because the disputes were overseen by trained patent judges under a strict deadline. In the past decade of PTAB's existence, the public has brought thousands of patents to the Patent Office's attention. The Patent Office has expertly addressed validity, reinforcing the strength of high-quality patents, but then canceling ones that never should have been issued. And as with any big new undertaking, that success has brought new questions. And all enacted laws, particularly those dealing with technologies and science, especially in an era when that is evolving so fast, they need to be revisited. They have to be updated from time to time. That's why I'm thrilled that Senator Tillis is the senior Republican on this committee, along with Senator Cornyn, and I just last week introduced the PTAB Reform Act of 2022. We had feedback from participants in the patent system, including the public broadly and businesses across the country, covering a vast array of sectors and technologies. We looked at concerns from all comers. The bill, the product of hard work and compromises, addresses the biggest concerns of stakeholders from across the spectrum. It can update the PTAB. It's important for a number of reasons. One question, of course, if a petition to the Patent Office to review a patent is meritorious on its face, should the Patent Office decline review anyway? Many believe all meritorious patents should result in a review. Many others believe it's harassing to patent owners to have the same members of the public able to request review of the same patent repeatedly over time when the patent owner has already defended the patent. So we address these issues, as we often do in the Senate, through compromise. While meritorious petitions to review a patent should generally be granted, serial petitions over time from the same or related parties will not be allowed. The big question, who has the authority to make a final validity decision? Civil servant PTAB judges or the politically appointed director of the Patent Office? Well, the Supreme Court last year resolved that the director is the final decision maker It left open questions how the director makes that decision. Well, we ensure that it must be open to the public. The public has a right to know. We should not have a patent system where any given PTO director can influence and decree decisions behind the scenes without transparency. And we also address the concern raised by small business patent owners. They had to pay to apply for a patent, and then may have to pay again to defend at the PTAB. It's expensive. We want to help small businesses shoulder the expense. Thus, if a small entity has not already decided to undertake the expense of litigation, the Patent Office will cover the expense of PTAB proceeding for that small business. Now, we have an extraordinary group of witnesses here. I'm excited to hear about their experience, what's worked, what needs to change, how PTAB reform will fit into the overall picture. Global Foundries is one of Vermont's biggest employers. It evolved from IBM, which had been there. Now, David Kane is a Vermont attorney. He's been involved in several PTAB proceedings. He's highly respected in the state of Vermont. He can tell us about his experiences in the semiconductor chip manufacturing industry. I know that Senator Tillis and Senator Cornyn share my belief the patent system should work for all Americans, all sectors. And I know I want to leave behind an even stronger patent system than what we were able to get through in the earlier patent bill, which I had the pleasure of working on. And so, Senator Tillis, you've spent so much time on this, I'll yield to you.
Thank you, Mr. Chairman. Thank you for holding the hearing today on the PTAB. I also want to thank you for your leadership and your continued partnership. It's allowed us to forge a path forward on this and many other important intellectual property related matters. You're a good friend, and next Congress, I'm going to miss you as a partner. Before I pass things over to our witnesses, I would like to provide some important context and history to what we'll be discussing today. It should come as no surprise that the chairman and I believe in the need for strong, reliable, predictable IP rights, something that we've championed for many years. And when I speak to IP rights, I speak to all forms of IP, patents, trademarks, copyrights, and trade secrets. It's because of this shared belief why we're convening this important hearing today. As anyone who follows my work in the subcommittee knows, I'm a firm believer in strong patent rights, and they're paramount to incentivizing American innovation, which fuels the growth of our country's prosperity and economy. This growth, in turn, allows the U.S. to maintain its global dominance across numerous industries and its reputation as the world's leading innovator. However, in order for patent rights to be truly strong, they have to be based in high-quality patents, which have undergone thorough review and meet all of the requirements of patentability. That's why I've made improving patent quality and patent examination process one of my key priorities. But as we all know, no matter how much we improve the front-end examination process, low-quality patents, especially in business and software fields, often do get issued. That's why the PTAB, the subject of today's hearing, exists. It exists as an alternative to district court litigation and as a mechanism to weed out low-quality patents. The PTAB, when properly constructed and administered, can play a vital role in our innovation economy. Unfortunately, for far too long, the PTAB hasn't been fair, and it hasn't been a fair and impartial forum that served its critical purpose. Instead, in years past, it's been a literal death squad for patent rights and has been weaponized by various companies to potentially bankrupt future competitors. Thankfully, during the last administration, a number of policies were put into place by my good friend, Director Iancu, to crack down on this abuse, policies which I strongly support. Andre's reforms ensured that the PTAB was truly fair and an impartial forum for all parties and not simply a place where patents go to die. That's why I've long supported trying to codify some of these reforms because as good a job as Andre did, a future PTO director could undo all of those positive changes with the snap of a finger. That kind of volatility in how the PTAB functions, the lack of certainty, doesn't create the type of innovation ecosystem that we need to ensure long-term research, development, and investment. My desire to provide long-term stability, certainly at the PTAB, and to permanently end some of the abuses we've seen in the past is why I've partnered with Senator Leahy to introduce compromise legislation, which has required both of us to sacrifice some of our priorities. The PTAB Patent Reform Act of 2022 ensures that inter-parties disputes remains an alternative to litigation while affording predictability, certainty, and fairness to the process for both the petitioners and the respective patent owners. The bill statutorily imposes the Phillips claim interpretation methods, stops abuse by serial petitioners, ends gamesmanship by big tech companies, adds greater transparency to decisions rendered by the PTAB, and prevents wild swings in terms of patent validity determination by providing consistency throughout the inevitable change of the U.S. PTO leadership. I'm also particularly proud of the fact that this bill will provide financial support for individual inventors, small entities, and micro entities to hold patents subject to a petition. This bill is a direct result of countless iterations and close collaboration with a diverse array of internal and external stakeholders. And let me be clear, this bill isn't perfect, and it isn't final. And I'm pretty sure that when it's final, it won't be perfect, but it should be able to address most of the concerns that we have across valid opinions at either end of the spectrum. This is the beginning of a process. I hope everyone will take this opportunity to work with us to provide long-term certainty and stability at the PTAB. All ideas can and should be on the table. If you don't like the compromise we've come up with, tell us. But don't just tell us you hate it. Give us ideas on how to write a better bill that will, in your opinion, be a better compromise. Again, Mr. Chairman, I thank you for holding this hearing. I look forward to the testimony from the witnesses, but if I may, as a point of privilege, I'd like to take a brief moment to formally welcome and introduce the newest member of my team, Peter Anthony Pappas, who I have nicknamed Juice. I won't get into the details. Peter's back here behind me. Peter joins us on detail from the USPTO, where he's a supervisory patent examiner. Peter also previously served as a special advisor to my good friend, Dr. Iancu, when he was PTO director. He brings a wealth of knowledge to this process, and he'll be an integral part of the discussions we'll have after this hearing. Welcome to the team, Peter.
Well, thank you, Senator Tillis. I know how hard you've worked on this. Senator Coons has worked on this, Senator Cornyn, and we look forward now to hear from David Kane. Please, I've already mentioned that he serves as patent counsel and legal director at Global Foundries, the largest semiconductor foundry manufacturer with headquarters in the United States. He's based at the Essex Junction, Vermont facility, JD from Pepperdine, engineering degree from Clarkson University, and highly respected in our state. Go ahead, Mr. Kane.
Thank you. Good afternoon, Chairman Leahy, Ranking Member Tillis, and distinguished members of the Subcommittee on Intellectual Property. Thank you for this opportunity to speak with you today about the important issue of PTAB reform. As Senator Leahy said, GlobalFoundries is one of the world's leading semiconductor manufacturers, with production in the United States, Singapore, and Germany. Our feature-rich chips enable nearly every sector of the global economy. Of the 5 at-scale semiconductor foundries in the world, GF is the only one headquartered in the United States and is a proud, long-standing partner and supplier to the U.S. Department of Defense. The semiconductor industry today involves producing billions of transistors on a single chip and requires the most technically complex manufacturing in the world. GF's success in this industry is born out of its innovation. GF's UF sites have produced 3 of the world's top 100 most prolific inventors of all time. Because of the RF technology innovation developed at GF's Vermont facility, the smartphone in your pockets almost certainly contains a GF-made chip. Due to the importance of innovation to GF and the critical nature of the chips we manufacture, America's patent system is exceptionally important to us. As an owner of more than 7,000 U.S. patents and as a U.S.-based manufacturer, GF seeks a fair and balanced IPR system for both patent owners and for petitioners. We count on the patent system to protect our investment in innovation and to prevent our business from being harassed by poor quality patents. Every year, GF faces infringement claims for patents that had no business being issued in the first place, which needlessly hurts our ability to supply semiconductors to the world. The cost of each semiconductor patent litigation defense can easily reach $5 million and beyond. The resources directed towards such litigation could otherwise be invested in capital expansion, R&D, both creating further jobs. By passing the Leahy-Smith American Invents Act over a decade ago, Congress made huge progress in curtailing the abusive patent practices hurting American industry. Allowing for efficient patent review by the technically trained and patent-savvy judges of the PTAB provides an efficient and effective tool to defend against poor quality patents. Bad patents can be dealt with for a fraction of the cost of litigation, while good patents can quickly be validated. Therefore, GF strongly supports efforts to improve the IPR system. The recent FinTIV factor discretionary denial practice has limited the availability of IPR review and inserted unfairness into the system. For example, defendants can be prevented from challenging a poor quality patent at the PTAB merely because the district court sets an unrealistically early trial date that will rarely, if ever, be met. Faced with potential denial, defendants must rush to prepare a petition and may not have sufficient time to search for prior art and may be stopped from relying on other prior art later. These early petitions filed within a few months of a district court complaint can create extra work for the PTAB itself. Such petitions generally occur before the patent owner has identified which patent claims it will be asserting, as well as how broadly it will be construing those claims. Consequently, the PTAB will need to spend time reviewing claims that may never be asserted and may construe them for purposes of validity more narrowly than the patent owner will in their infringement case. The proposed PTAB Reform Act resolves these issues by solidifying the one-year window for bringing IPR petitions, while also ensuring that petitioners are not allowed to bring serial challenges. These common sense proposals provide fairness to both patent owners and petitioners. GF appreciates Congress's commitment to fostering American innovation and strengthening the greatest patent system in the world. Thank you very much for allowing me to testify and share GF's perspective today.
Thank you very much, Mr. Wilson. Mr. Wilson is Director of Patents in the Legal Division at SAS Institute, Inc., the data analytics software company. He began his legal career as a patent and intellectual property litigator with the firm of Jones Day, is a Juris Doctoris from Syracuse University College of Law, bachelor's degree from Pennsylvania State University. Mr. Wilson, please go ahead, sir.
Thank you, Mr. Chairman. My name is Tim Wilson. I am patent counsel at SAS Institute. I also am an adjunct professor at the Southern University College of Law, a great historical black college and university law school, as well as I'm president of the Patent Quality Education and Training Foundation, where we try to help improve diversity in patent law through working with the Thurgood Marshall College Fund to help support HBCU graduates to getting into patent law. I'd like to thank Chairman Leahy, Ranking Member Tillis, and the members of this subcommittee for holding this hearing to explore potential reforms to the AIA. I'd specifically like to thank Chairman Leahy and Senator Cornyn for their leadership during the original negotiations with respect to the AIA. Because of their leadership, there was a great spirit of compromise, even though it was often a difficult negotiation. It led to the most significant reform of the patent system since 1952. The American Invents Act has largely done its job by leading to a large decrease in the number of patent litigations. In 2011, we had almost 8,000 patent litigations, and that has been brought back to between 3,000 to 4,000 annual patent litigations, and I think that's a great thing. In pre-AIA case that SAS faced, a company called Juxtacom, they were a failed company that was left with a single patent who got funding from external sources to sue dozens and dozens and dozens of companies that actually made things, costing all of those companies millions of dollars and costing SAS between $5 and $8 million just to get that patent thrown out by a judge on summary judgment. A huge waste of resources. As a holder of over 600 US patents, SAS has always been interested in improved patent quality. We have a wide variety of inventors at SAS who work on the cutting edge of software technology. The two significant elements of the AIA discussions earlier were patent litigation reform and the creation of the PTAB. At some point during the negotiations, it became obvious that no meaningful reform or compromise could be made related to patent litigation. It was a little disheartening to lose that element, but we continued to work together under the chairman's leadership, and the result, many stakeholders working together, was the PTAB. Recently, the PTAB decided the Fintiv case, which allowed the PTAB not to institute a petition that would otherwise meet the threshold for institution. That would be based on a complex set of balancing additional factors. This decision undermines the simple test that Congress set forth in the AIA and leads to potentially substantial uncertainty to the parties because good petitions may be denied. It also negatively impacts the public because invalid patent claims are arbitrarily allowed to survive review. As a patent owner, SAS appreciates that there may be abuses of the system by so-called serial petitions. We don't believe that this is a pervasive problem, but we're happy to participate in finding a solution to that problem as well. It seems that we are once again looking to Chairman Leahy, Ranking Member Tillis, and Senator Cornyn for leadership on another PTAB Reform Act. I think it's great to use the PTAB Reform Act as a framework to find a good compromise. Thank you, and I look forward to your questions.
Well, thank you very much. I should note that Senator Tillis left to vote, and I don't know what. Okay, and we'll be going back and forth. We'll keep when somebody comes back, and then I can go and vote. Robert Giles is Senior Vice President, Chief IP Counsel at Qualcomm Incorporated, for his responsibility for designing and developing their global IP portfolio. Received his JD from the George Washington University, bachelor's from the University of Illinois, Urbana. And Dallas, good to have you here. Please go ahead.
Thank you very much. Chairman Leahy, Ranking Member Tillis, and members of the subcommittee, My name is Bob Giles, and I'm Senior Vice President and Chief Intellectual Property Counsel at Qualcomm. I appreciate this opportunity to testify on behalf of Innovation Alliance, a coalition of research and development-based technology companies that believe a robust patent system is critical to U.S. technological leadership and our economic and national security. For decades, the constitutionally protected U.S. patent system has secured our global leadership position in incentivizing the research and development needed to invent groundbreaking technologies. However, in recent decades, our position has been threatened by judicial and legislative actions that weaken patent rights. To maintain the United States' strategic interest, the PTAB must be reformed to achieve its statutory purpose as an efficient alternative to district court litigation. The Stronger Patents Act would promote balance and fairness at the PTAB and would advance American innovation leadership. The PTAB Reform Act would do the opposite by weakening the U.S. innovation ecosystem. Robust patent protections are foundational to the U.S. economy and national security for two reasons. First, they serve to appropriately incentivize companies to invest in costly and risky long-term R&D needed for leadership in emerging technologies such as AI, IoT, 5G, and 6G. Second, patent rights facilitate commercialization, collaboration, and follow-on innovation by granting exclusionary rights in an invention for a limited time in exchange for public disclosure. Patent protections assure that rights to practice an invention can be readily bought, sold, or licensed, allowing patent owners to reinvest those revenues in further R&D. Despite the critical role that patents play in the U.S. economy, patents have been under attack in recent years by actions that impose substantial obstacles on inventors. Chief among these is how the PTAB has evolved. By permitting any party to challenge and invalidate a duly granted patent by a mere preponderance of the evidence, the PTAB has led to gamesmanship and the invalidation of patents at an alarmingly high rate. USPTO data show that the PTAB institutes IPR in nearly 2/3 of petitions filed. The data further show that once IPRs are instituted, they result in cancellations of at least one claim in 80% of the time, and cancellation of every claim 60% of the time. These high invalidation rates have led one former judge on the Federal Circuit to call the PTAB a patent death squad responsible for killing patent rights. Infringers have used the PTAB to harass and intimidate small companies. One example is Centripetal, an inventor of cybersecurity technology. Centripetal initially attempted to partner with Cisco and disclosed its patented technologies. In the end, the relationship broke down, but Cisco implemented Centripetal's technology anyway. Centripetal had to resort to sue Cisco to defend its patents in court. The court found that Cisco willfully infringed, ordering Cisco to pay $1.9 billion in damages. At the PTAB, Cisco sought to strengthen its negotiation position against Centripetal by challenging 9 patents using 14 IPR petitions. The PTAB invalidated all of the claims of 6 of the patents and some of the claims of another patent, a much higher invalidity rate as would be expected in district court. The Innovation Alliance urges Congress to pass the Stronger Patents Act to strengthen U.S. competitiveness and global leadership. Stronger would, 1, empower U.S. inventors to protect their patent rights against infringers by implementing a common-sense framework for granting injunctions, and overhaul the PTAB to ensure its proceedings are conducted in a fair and consistent manner in line with federal courts. Importantly, for example, Stronger would prevent petitioners from filing a subsequent IPR petition on the same patent claim if the petitioner failed to show a reasonable likelihood of success in its first IPR. In contrast, the Innovation Alliance urges senators to oppose the PTAB Reform Act because it would further tilt the playing field towards infringers. Specifically, the PTAB Reform Act eliminates the fintive doctrine, which allows the PTAB to apply discretion to deny institution of a petition in order to prevent abuse, promote efficiency, and conserve resources of the USPTO and individual parties. Further, it permits challengers to file an unlimited number of petitions against a single patent. It would also create a legally questionable backdoor, giving standing to parties who would not otherwise have it. These changes harm inventors and move the patent system in the wrong direction. Thank you again for inviting me to testify today. The Innovation Alliance stands ready to work with you to ensure that U.S. patent law promotes economic and national security.
Well, thank you, Mr. Giles. And Professor Anderson is a professor of law at American University. His academic articles have been cited by the Supreme Court, the U.S. Court of Appeals for the Federal Circuit, and the New York Times. Professor Anderson clerked on the Court of Appeals at the Federal Circuit. He practiced patent litigation at Latham and Watkins. I spent a lot of time not as an appellant, but as a friend of many of the members of the Federal Circuit Court of Appeals, as the professor probably knows. And he received a JD from Harvard Law School, bachelor's degree in physics from the University of Utah. And Professor, please go ahead, sir.
Good afternoon, Senators. Thank you, Chairman Leahy, Ranking Member Tillis, and the other members of the subcommittee for the invitation to testify. It's an honor to testify on the predictability and fairness of proceedings at the Patent Trial and Appeal Board. I'm a professor at American University, Washington College of Law, and my areas of expertise are in patent law, federal courts, and intellectual property. A specific focus of my scholarship has been directed towards federal courts, federal district courts, who seek to attract patent cases to their courtrooms. This court competition for patent cases, I believe, is a threat to the judiciary's legitimacy, not just in patent law, but across other areas of federal law as well. It is with this concern in mind that I will focus my testimony today. I will begin my testimony by briefly describing how the PTAB's FinTIV ruling has been used by federal district court judges who seek out patent cases, and how that active solicitation of patent cases threatens to erode public confidence in the judiciary. In 2021, roughly 25% of all patent cases were heard by a single federal district court judge. As Chairman Leahy and Senator Tillis referenced in their November 2021 letter to Chief Justice Roberts, this extreme concentration of patent cases is troubling for the judiciary. I agree with Chairman Leahy and Senator Tillis' views on the current problematic state of patent litigation. This extreme concentration of patent cases and judges actively encouraging plaintiffs to file in their courtrooms undermines the public perception of fairness in judicial proceedings. But this hearing is about the PTAB. I believe the PTAB has been a great benefit for the U.S. patent system by providing a cost-effective means of challenging the validity of patents. This leads to a strengthening of the competitive landscape and is a positive for the American public. But I also believe the FinTIV decision at the PTAB has led to increased uncertainty. As Senator Tillis said in his November 2021 letter to the director of the PTO, it has led to harmful incentives for forum shopping and inappropriate judicial behavior. Furthermore, just this morning, the PTO issued guidance on the application of FinTIV that limit FinTIV's applicability. Today's PTO guidelines are welcome on the whole, but I would suggest that the PTO ought to rescind the FinTIV rule entirely. The PTAB's FinTIV rule is based on the laudable notion that the PTAB ought not institute review of a patent if a district court or the ITC is going to issue a ruling on the patent's validity at an earlier time. But the current 6-factor test provides virtually no certainty of outcome, and worse, is influenced by plaintiffs who can strategically, file their cases in an effort to avoid PTAB review. Plaintiffs who want the PTAB to avoid PTAB review can choose to file their case in a district court that has a reputation for not issuing stays and setting very early trial dates. These dates are not good indicators of when a district court will issue a decision. A recent study found that 94% of those trial dates relied on by the PTAB in FinTIV turn out to be inaccurate. The FinTIV ruling forces the PTAB to analyze the trial dates of district courts and to grapple with comparing the duplicative effort between the district court and the PTAB. Furthermore, it forces parties to waste attorney hours arguing about the 6 cumulative factors. A much better and easier solution would be to eliminate FinTIV entirely and limit the PTAB's institution decision to those factors that are enumerated by Congress, including the 1-year ban. Eliminating FinTIV would also have the benefit of eliminating the possibility that district courts that set aggressive trial dates in an effort to preclude PTAB review. The PTAB would be freed from the labor-intensive analysis involved in FinTIV, and district courts would not be able to use trial dates in an effort to avoid PTAB review and thereby attract patent plaintiffs. Thank you for your time, and I look forward to your questions.
Well, thank you very much, and I'll begin with Mr. Kane. I think everybody knows there's currently a chip shortage that's affecting all Americans. There's even car manufacturers of popular vehicles have them sitting in their lot just because they are missing a few chips. Chip manufacturers like Global Foundries, with what I believe is an exceptional facility at our home state, components, phones, cars, computers. Patents are an important part of your business. I understand Global Foundries has over 7,000 U.S. patents. When we passed the Leahy-Smith American Invents Act 11 years ago, we wanted to make sure the patent office could take a second look at patents that are of particular relevance to the public, review them, and so on. In your experience, Mr. Kane, has the PTAB been a fair adjudicator of patent validity? Make sure you read.
Thank you, Senator. Certainly. We've very much been happy with the PTAB, both as a patent owner and as a petitioner. As you said, there's an extreme amount of innovation going on at our facilities. Every chip we put out must have hundreds, if not thousands, of pieces of innovation inside of it, and we do count on the system to protect that innovation. And we've seen very fair and very reasoned decisions coming out of the PTAB as to the validity of those patents.
Do you consider the PTAB judges preferable to an ordinary court and jury?
PTAB judges are specially positioned with their technical background and the fact that they live and breathe patent law every day. It is their bread and butter, novelty and non-obviousness. And so they have a better look at such issues than almost anyone in the world.
I had a dear friend of mine, Judge Lynn, who now has senior status in the Federal Circuit, and I remember talking to him about some of these patent cases and realized this is a specialized area. Let me ask Professor Anderson. I've always thought the PTAB could be forum predictable and fair, but a previous patent office director began using the discretion that's in the Patent Act to deny review of patents based on the status of ongoing litigation in district courts without regard to the merits. The kind of discretionary denial injected uncertainty, I believe, into the patent system. I understand that just today, Director Vital, and we've mentioned this, released new guidance cutting back on the impact of that policy. I believe the statute should be as predictable as possible. So, Professor, my understanding is projected trial dates are inaccurate 94% of the time. A discretionary denial policy built around this one, I feel, would cause uncertainty and unpredictability in the patent system. Do you agree?
Yes, Chairman, I definitely agree. And even worse than that, I think there's some gamesmanship involved in where you file your case and in order to avoid the PTAB. So I mentioned there's one district court that has 25% of patent cases, and one of the appeal to plaintiffs, I gather, is that filing in that courtroom makes it less likely that PTAB will review your patent under the FinTIV case. And that's why I think this act goes a long ways, and the PTO's actions this morning go a long ways towards limiting that discretion.
Well, in fact, going on that, Senator Tillis and I wrote to the Judicial Conference about the ability of patent owner plaintiffs not only to pick the venue but to pick the precise judges. I think what you're referring to is a district court judge who's promised patent owner plaintiffs a trial date will be soon enough they can deny them discretionary denial at the PTAB. 25% of the district court patent litigation in this whole country is being handled by that single judge. Does that skew the patent litigation in this country?
Yes, I think having 25% of the patent cases or any type of case before one judge is not the system that the Constitution or Congress designed. And so I think having that many cases, that much power in one judge's hands is not something we want to encourage, for sure.
Thank you. I'm going to go and vote. I'm going to turn it over to Senator Tillis, who knows this committee inside and out. Thank you.
Well, thank you all again for being here. I worked in research and it's especially good to see somebody representing SAS here. Jim Goodnight is truly an American success story, and SAS is actually a product that I had some involvement in the implementation of back in my days at Price Waterhouse. And speaking of my days at Price Waterhouse, anytime I have a thorny subject that I'm trying to sort out with my business clients, I try to get people into the room, all of whom I respect and all of whom I want to produce a good outcome for the company. And now for this bill, I ask them a simple question: give me a red, yellow, green. So just going down the line, we'll start with Mr. Kane. Tell me what you think is good, that is green, yellow, needs work, red, a problem. And then we'll go down the line. That gives y'all time to prepare.
Are you asking what's good in the proposed bill?
Yeah, red, yellow, green. What's good? You don't even have to talk about the good. Give me the yellow and the red.
The worst case is yellow. This is a move in the right direction across the board, much more green.
Good. Mr. Wilson.
Yeah, I would say that the bill has not everything we want. If it was our choice, we would remove the discretion from the director and from the PTAB not to institute good petitions. But I think there's a fair compromise here amongst all of the interests. And like you said, putting everyone in the room is probably the best thing to do. We support this process. We think, all of the compromises that have occurred so far have been positive, and I think yellow is probably where we are across the board.
Mr. Giles.
Thank you very much. First, I'd like to express our appreciation for being involved in this discussion. It's a very worthwhile topic, and we are very dedicated to making sure that the patent system is as strong as it possibly can be. It is as you mentioned in your opening remarks, it is foundational to the American economy and to innovation throughout this country. There are, and I do believe there has been some compromise in this bill. The adoption of the Phillips standard for claim construction, to unify that across the district courts and the PTAB, I think, is a step in the right direction. But overall, we look to the provisions that are set out in the Stronger Patents Act that would be a little bit more fair and balanced with the patentee in mind. And so I would say, if you're going to force me to say red, yellow, green, I would say it's a yellow, because I do believe the process is moving, but we still stay in line with the Stronger Patents Act.
Mm-hmm. Mr. Anderson.
Thank you. I would say this is mostly a green bill. I am in favor of much of what's in here. I would like, Mr. Wilson said, would like to see certain other things in the bill that aren't there, but this is a compromise, and I recognize that, and this is a good bill overall.
Well, I just want to restate what I said in the opening statement. I also, before I joined Price Waterhouse, I worked in research and development at Wayne Laboratories up in Boston. So we were constantly iterating through ideas and refining the product. We use a similar methodology for engaging stakeholders. So anyone out there who's saying, boy, I wish they'd mentioned that red item, I'm telling you, come to the table and let us examine a way that we can make this a win-win. But we have to make progress. I think with that, I'm particularly interested after the hearing if you could give some more meat around the bones on the yellows to get them to green or blue-green. Help us do that. Give us feedstock for future discussions that we'll have, and I'm committed to engaging as many people as possible. Hopefully we can satisfy some. We won't be able to satisfy all, but that's the nature of the work that we do up here. Senator Coons.
Thank you, Senator Tillis. I'd like to thank you and Chairman Leahy for the chance to work with you. I appreciate your opening comment that this bill isn't perfect or final, but the beginning of a process, and I look forward to working with you on that. I think reforms that position IPRs as an efficient alternative to district court litigation, which was really the original core intent of the AIA, are needed. But looking over this bill, I'm concerned that eliminating the PTO's ability to consider co-pending litigation in deciding whether to institute is a step in the wrong direction. Because I think hardwiring parallel proceedings into the AIA increases costs by encouraging duplicative proceedings. And in my view, that doesn't benefit the public or the patent system. So any statutory provision to address serial petitions also has to adequately protect versus repeated attacks on potentially valid patents. So as you know, I'm committed to the Stronger Patents Act, which I've worked on for a number of years, and it would limit the ability to obtain multiple and repeated AIA review proceedings. So I appreciate the efforts of my colleagues and friends, Senators Leahy and Cornyn and Tillis, to bring together stakeholders and explore these thorny issues and try and come to a workable compromise. And I look forward to continuing to work with you to strengthen patent quality, the patent system, and to come up with a workable solution. Mr. Giles, if I could, just at the outset, what are the benefits to the public and the patent system of evaluating concerns about redundant and duplicative proceedings in deciding whether or not to institute an AIA trial?
Thank you very much. The definitive doctrine allows the PTAB to review whether or not its resources are beneficial to the process of resolving the dispute. And if you were to remove that that discretion from the PTAB, you're much more likely to have parallel proceedings going on at the same time, one in district court and one in the PTAB. And the way that the system is set out right now, especially if you remove definitive discretion on behalf of the PTAB, that will astronomically increase costs for small businesses to be able to assert their patent rights. It's not easy to assert a patent in district court. It's not easy to defend a patent at the PTAB. And it's incredibly costly to do both. And to layer on a burden of having to do that in two jurisdictions at the same time is very detrimental to, especially to small companies that are trying to assert their patent rights.
Thank you. Mr. Kane, why don't we pursue that line? In terms of the interests of small inventors in particular, what's the benefit to them if accused infringers can pursue patentability issues in both an IPR and district court proceeding at the same time?
Thank you. Specifically for small inventors? Well, one of the really thoughtful sections of this proposed bill calls for the IPR defense for such small entities to be handled, to be paid for by the PTO itself, which I think is an exceptional benefit.
How viable do you think that is, and what kind of cost do you think that might add up to?
I don't know the statistics, but in my experience, it's very, very infrequent that a small or individual inventor is not only asserting their patent, but is brought into the IPR system.
If I could, Mr. Wilson, there was a recent article in Bloomberg that said fintive denials are falling. It concluded that review was denied this year in less than 10% of cases in which the board evaluated definitive factors, and it cites petitioner stipulations not to raise the same patentability issues in litigation if the PTAB institutes. Would requiring these so-called Sotera stipulations make IPRs a genuine, a valid alternative to litigation?
Well, I think that one has to remember where we are when a PTAB petition has been filed, that we're not just out of the blue filing a petition, that it's a company generally who has been sued in district court first. And so when you say it's a small company, a small inventor, I think you ignore perhaps the financing that those entities have, either through a opportunity through a law firm or financing through what has been happening more and more are kind of hedge fund money. And so when you say it's a small inventor, you see, I think that's a little bit misstating who...
This question wasn't, in fact, my question to you wasn't limited to small inventors. It was just about whether or not the Sotera stipulations are narrowing the number of definitive denials. If you'll forgive me, I'm near the end of my time. Mr. Giles, just one last question, if I might. What's the largest concern you've heard from patent owners that they want to see addressed in a PTAB reform bill?
I'd say the largest that's applied by the PTAB. So at the PTAB proceedings, it's the level is, or the burden of proof is preponderance of the evidence, which is much lower than it is in district court, which is clear and convincing evidence. And this burden of proof has led to the significantly higher rates of invalidation at the PTAB than in the district court. And so the two venues are not on an even playing field. And if the PTAB is acting as a alternative, faster forum for the district courts, it should also align with the burden of proof. Should also align there.
Thank you. Thank you to all the witnesses. And Mr. Chairman, Mr. Acting Chairman, thank you.
On behalf of the chair, Senator Blackburn.
Thank you. And thank you to each of you for being here today. Mr. Giles, let me come to you. Over the last several years, a lot of our innovators in Tennessee, people who are smaller innovators, or maybe they work for a large corporation, what they've seen is big tech companies end up coming at them on patent infringement. And how can we ensure that PTAB is not enabling the larger tech companies to steal patents from small businesses and innovators?
So the analysis that I've seen, the data that I've seen is that the big tech companies are actually the biggest users of the PTAB process. It was a process that was put in place with smaller inventors in mind, but as the use of the PTAB has progressed, it's become more and more used by larger corporations to actually put pressure on smaller companies to try to force them to to lower their negotiating position and to possibly so that they could acquire them. I think it was Chief Judge Michel that said, Judge Michel that called out the fact that these large corporations are using the PTAB in order to pressure smaller companies with patents to not pursue their rights, to relinquish their rights to these large corporations that then usurp them and not have to pay the royalties.
Then some estimates that I've seen, PTAB invalidates partially or fully, I think 84% of the patents it fully adjudicates. So talk to me a little bit about the trend, and does it indicate a problem with the PTO when it is originally granting the patents, or why is it that there is a change of heart in that process, and what could be causing that invalidation rate?
So the invalidation rate by the PTAB is much higher than one would expect, and and part of that is because of the burden of proof that the PTAB uses. They actually use the same burden of proof that's used during the prosecution process when the patent office is examining an original application. But they use that in a much, the patentee is in a much more limited position during the PTAB proceedings and is unable to, very likely unable to amend the claims. I know that there's one amendment allowed, but those are granted very, very rarely. And so, so by having this much lower burden of proof during the PTAB proceedings, it leads to these higher invalidation rates.
Okay, then how should that be fixed? What are the steps we should take? Because when I'm talking to people that are innovating for the auto industry, innovating for, electric engines, innovating in the music industry for delivery systems, innovating in health IT, they're frustrated.
Yes, and Qualcomm is a large innovator as well, and we are innovating in many of those same areas. And what we can do to try to fix that is to equate the burden of proof in the PTAB proceedings with that in district court. So it should be using a clear and convincing evidence standard instead of a preponderance of the evidence standard to more align.
So then how does that invalidation rate at PTAB compare to the district court?
So in the district court, these are rough numbers. In district court proceedings, you can expect about 30% of the claims are invalidated. And in the PTAB proceedings, it's at least twice that high, if not more.
Yeah, it's higher. Thank you, Mr. Chairman.
On behalf of the chair, Senator Cruz.
Thank you, Mr. Chairman. Welcome to each of the witnesses. Our founders included in the United States Constitution the protection not just of property rights, but also specifically of intellectual property rights. Article 1, Section 8 makes clear Congress's duty to ensure the exclusive right of inventors. In fact, the word right only appears in the Constitution in two places. First, and forgettably, in a subject heading describing the rights of members of Congress. The second place it appears is in the context of patents, specifically that the Constitution guarantees the rights of authors and inventors to secure the benefits of their writings and inventions. I have some concerns when those rights, which often amount to a person's livelihood, can be stripped away by unaccountable bureaucrats, not elected, nor appointed by the President, nor confirmed by Congress. I know that my colleagues have been working hard on the PTAB Reform Act, and I applaud them for their efforts. I'm sure they would agree that their bill is an important one. And as such, I would hope they would likewise agree that any bill that would significantly alter the patent landscape, affecting billions and billions of dollars a year and implicating America's national competitiveness and maybe even our national security, should be entitled to a full and fair markup hearing. Not a truncated, lightly attended hearing, but a full markup hearing by the full committee. When the stakes are so high, as they are in the context of billion-dollar patents, the cost of unintended consequences could be disastrous, not just for inventors and companies, but for America. And so I would urge my colleagues on the Judiciary Committee, particularly Chairman Durbin and Ranking Member Grassley, to schedule a markup hearing on this bill for the full committee. I do have significant concerns with PTAB itself. Its origins are somewhat suspect. Google, which enjoyed an amazingly cozy relationship with the Obama White House, sent their deputy counsel and their head of patent strategy, Michelle Lee, to head the PTO and establish PTAB. Interestingly, PTAB became a very friendly forum for Google and other big tech firms to challenge the rights of inventors. For example, in 2020, PTAB found 84% of the patents it fully reviewed to be invalid. and many patent owners that successfully defend their patents against big tech in district court are immediately dragged before PTAB, where they have to defend it anew. Big tech obviously loves PTAB. 18 of the top 20 filers in PTAB are big tech. Out of the PTAB petitions filed by the top 10 petitioners during 2021, Samsung, Apple, Google, Intel, and Microsoft collectively accounted for 81% of all such petitions. But it isn't just big tech that loves PTAB. China has also found PTAB is a useful tool towards invalidating American patents. Chinese companies such as ZTE and Huawei are prolific petitioners at PTAB. Again, the risks of getting this wrong are severe. If this bill should move forward, let's do so under the full light of day, subject to a full and fair markup hearing. The American people deserve no less. And Mr. Giles, I want to ask you a couple of specific questions. Number one, do you agree with what I just said, which is the consequences of changing this system are significant and should be considered carefully for unintended consequences?
Yes, I fully agree with that. The consequences of conserving the patent system are real, and they could have a tremendous effect on the United States economy and national security.
So you also urge the passage of the Stronger Patents Act. In your judgment, how would this act ensure fair proceedings?
So there are many ways listed in the...
Apparently the patent on the microphone has expired.
So we can work on the communication technology here. Okay, so there are a number of things laid out in the Stronger Patents Act. One is increasing the burden of proof for PTAB proceedings. Another is limiting the number of proceedings that a petitioner could bring. You can't bring subsequent proceedings. You can't bring multiple proceedings at the PTAB to serially attack and to continue to attack patent rights and put smaller companies at a disadvantage. And there are a whole number of other protections laid out in the Stronger Patents Act.
Thank you.
Tillis?
Thank you all. I just had a few things. I did ask you to go back and give me some more substance behind things that you would consider to be areas where you have concern, my yellow. But really quickly, rapid fire. What are your thoughts regarding the introduced bill's ban on institution of serial petitions? We'll start with Mr. Anderson.
That for me is a yellow. I'm not a big fan of reducing the opportunities to challenge patents. Just like in district court, there's no limitation on how often a patent can be defended. I don't think you should have the same. I think the same thing should apply to the PTAB.
Mr. Giles.
So I think that provision goes part of the way, but doesn't go the full way. I actually do think that petitioners should be required to limit the number of petitions that they are able to file altogether, not only serially but in parallel. And right now, the bill seems to open up the door to parallel petitions, which I will say is actually very similar to the process that is undertaken in district courts. District courts always require the parties to limit the amount of claims that they bring, limit the amount of references that they use, limit the scope of the invalidity proceedings in district court, and it should be more aligned along those, or it should be more along those lines in the PTAB as well.
Mr. Wilson.
Yes, we're yellow on that. I think the thing that it forgets is that the reason that we're at the PTAB is that patent infringement cases have been filed against us. If we are, honest about it, we want to be able to file our petitions. The public is benefited by having the petitions filed because, they're often successful, and the patents that shouldn't have been issued in the first place are not going to be the subject of litigation any longer.
Mr. Kane.
Thank you. As a patent owner and as a petitioner, We find that it strikes a good balance and is a reasonable compromise for the patent system.
Okay. In the interest of time, I'm not going to take you off. I wanted to get to some of the ones that hopefully we can get more feedback on. Things that I'd be interested in if you could provide us with feedback after the committee, the codification of the Phillips standard, the funding of small and micro entities who face challenges at the PTAB, and got a couple of other ones in there, but if you could drill down, I just really want your candid assessment of where we are so that we can work together to make the bill better. Thank you, Mr. Chair.
Thank you, Senator Tillis. I'm looking at PTAB as some of the biggest beneficiaries, of course, we know are small businesses, entrepreneurs. I worry about the specious patent assertions. Patent, if you have one, is not something constitutionally can never be touched or looked at. I think of some of the baseless patents, sunglasses strap, a crustless peanut butter and jelly sandwich, or the method of swinging in a swing. You know, they're ludicrous. PTAB proceedings are a lot less expensive than litigation. I'm trying to figure out how to get the cost paid in full, including attorney fees for small business patent owners. PTAB's designed for small businesses, entrepreneurs, and I want to make sure it works for them. So let me ask a couple of questions. Mr. Wilson, we've heard that discretionary denials of PTAB proceedings create uncertainty and unpredictability. I'm told that under a policy that requires filing PTAB proceedings long before the one-year time bar, PTAB review becomes less useful from a business perspective. An accused infringer doesn't know what patent claims will be asserted, has to file overbroad petitions to the PTAB. Accused infringer does not have time to do a thorough prior art search. Accused infringer has no way to know whether the patent office will deem the petition too late because there are amorphous public guidelines saying it was too late. Now, after the PTAB's discretionary denial policy was announced in the Fintiv case, what challenges has your business faced in the PTAB process, either in deciding to go to PTAB or in the process of the proceedings? How's that for an open question?
Thank you, Mr. Chairman. I think we have to be cognizant always that the way that you get to the PTAB is because someone has filed a lawsuit against you. And that's, in my experience, never a good place to be. You have to analyze whether or not to spend the money to prepare a petition very quickly with a lot of effort, and you have to go through that process while evaluating, well, maybe going to court is better, or maybe we ought to settle the case. So there's a lot of factors up in the air while you're trying to determine whether or not to go to the PTAB. And it's a very expensive process either way, but I have to say the PTAB is a much more cost-effective way to get to a decision, in my experience, than patent litigation. Now, if we're going to go outside of the statute that we all agreed to, the American Invents Act, and come up with additional considerations that the Patent Office is going to kind of unilaterally create and determine that, we may now kind of randomly not accept a patent petition, a PTAB petition that would have otherwise been acceptable. I think that is not doing us a service. I think that we should go back to the system that the American Invents Act was created to do. And let me just remind my colleagues about a couple of things. One is during the AIA negotiations, we had small business, retailers, banking, automakers, restaurateurs, all here participating in the process. They're not here this time, and I think it's because the PTAB the American Invents Act did its job. We shouldn't necessarily change that by the patent office alone.
So as a patent owner, you'd rather have your patent's validity adjudicated by the PTAB with an analysis?
Yes, Mr. Chairman, absolutely. I know when I'm thinking of asserting one of my patents against another company that I am likely to have that patent reviewed at the patent office through the PTAB process. It is part of the analysis that goes into determining whether or not to bring a case in the first place, what patents to bring, what claims to assert. All of those things are things that we can adequately take into consideration before we determine to file suit.
Well, sort of following on this, Mr. Giles, I know the Innovation Alliance has had some concerns, but you've also provided a lot of feedback during the drafting of PTAB, and I think I can speak for Senator Tillis and Senator Cornyn and myself. We've appreciated that, and we've addressed many, if not all, the rounds of your input. And so we've tried in earnest to address them. We recognize concerns about inventors being harassed with serial petitions. Isn't it helpful that if our bill ensures that inventors are immune from successive petitions by the same and closely related parties?
Yes, it is helpful that the bill moves in that direction, and it would be better if it went a few steps further, as outlined in the Stronger Patents Act, which limits the number of petitions that can be filed altogether.
And I appreciate that. We retain the Patent Office's discretion to decline most proceedings. And do you support the Patent Office having discretion to deny institution?
Yes, and I do think others have commented on the FinTEV situation, and I do think that the Patent Office should still be afforded the ability to deny institution based on the proceedings in a district court proceeding. And many of the issues that people have raised have been worked out by the Patent Office over the past few years. People are citing to trial dates moving, and the data that underlies that is actually trial dates under the COVID restrictions that were happening at the same time. So I don't think it gives a very accurate depiction of when a trial date actually stays. And the director actually also came out today and cleared up the guidance, even though it was actually in some of the orders by the PTAB judges already, but cleared up the guidance that
Did you agree with what the director came out with today?
I haven't had a chance to completely analyze it. It just came out.
Let me make that as a question for the record. If you could respond, let us know whether you agree or disagree. If you disagree, why? Okay?
Sure.
You have plenty of time.
Oh, yes, yes.
And we made PTAB affordable for small business owners. We covered their expenses, including attorney's fees. Isn't it helpful that our legislation makes the process completely free for small business inventors?
Is that to me, sir?
Sure.
Okay. I've looked over the provisions of the small business support portion of it. I would actually welcome a much more full dialogue on that portion of it, because I do think there are some nuances to it where it may not get to the point where it's actually supporting a lot of the small businesses.
And my last question is, Mr. Kane, I'm committed, and I know Senator Tillis is, to transparency throughout government. At PTAB, the judge issues decisions, as you know, but we don't know if behind the scenes a patent office director or others acting on the director's behalf are influencing PTAB judges to decide certain cases in certain ways. Would it be beneficial to our patent system if the public knows when decisions are made by the director rather than the independent PTAB judges, and what the director's reasoning might be?
Thank you, Senator. It certainly would be very valuable to the public, patent owners and petitioners. You want, in any area of the law, you want certainty and predictability, and the more transparent you can be, the less appearance of impropriety is likely.
Thank you. Well, I have a number of letters of support from different groups, and if you have no objection, I'll enter them into the record. And should we keep the record open for 7 days? We'll keep the record open for 7 days, and if people have things that you, either from your answers that you want to add to or change, feel free. And you have nothing?
Yeah, Mr. Chair, just the record will be open for 7 days. The dialogue is going to continue beyond that.
Oh, that's for sure.
And I just want to be absolutely certain.
That's called New England understatement, even though it's not.
I just want to make it clear that we're in the business of debate and compromise. That's what we do. Senator Leahy and I do that every day. But you can't address a concern that you don't know. I appreciate people coming forth, stating their opinions. My office is committed to listening to them. The only thing I don't tolerate are guerrilla tactics to try and undermine what we're trying to do here. I don't expect any of you to be in that category because you're here testifying before us, but I would encourage anyone else who's watching what we're doing here to engage. Thank you, Mr. Chair.
Thank you, and we stand in recess.